Good morning. Welcome to the Immigration Talk Show with attorneys and experts brought to you by Hire IT People. My name is Dan Nandan. I'm the CEO of Hire IT People Inc. I will be hosting and moderating this show today. We have a lot to cover in the next 1 hour, so stay tuned. For any reason, if you're not able to watch the entire show, you can rewind by going back to one of the social platforms, Facebook, LinkedIn, Twitter, and YouTube. Search for Hire IT People on our pages. And we are also streaming now on 20 different Facebook groups. So you can watch a rewind at one of these groups, but you can share this. We just have people increasing. It's a hybrid show between a Facebook live stream and then Facebook and other social media platforms, along with a conference call. I'm just flashing the numbers to call. You can sit on the conference call queue if you have a question. You can also send us a chat message um, on the one of the social media platforms. I will try to display the message or read out your question to the attorneys, but we'll open up the Q&A after about 20 minutes roughly. So we expect to run this for about 40-45 minutes to an hour. So before we get started, today we will be discussing about the EAGLE Act, the Equal Access to Green Cards for Legal Employment, which was a bill introduced by Representatives Lofgren and Curtis for bipartisan legislation to eliminate the arbitrary per country limits on employment-based visas. And if time permits, we'll also talk about H-1B visas, the national interest exceptions, travel, and the consulates. And if you'd like to get updates on our upcoming talk shows, immigration talk shows with the Murthy Law Firm, you can text keyword H1B to 732-800-9205 or follow us at Facebook, Twitter, LinkedIn, and YouTube at Hire IT People. Um, and if you'd like to ask a question, please make sure you press *6 if you're on the conference call. I see a bunch of them already sitting in the conference call queue. Thanks for joining, guys. And before I get started with the topics here, Murthy Law Firm does not need an introduction. They've been in business for 27 years serving the community. And today we have five attorneys, including none other than Ms. Sheela Murthy, along with her colleagues, Aaron Finkelstein, sorry if I said it wrong, Kevin Andrew, Christopher Drynan, and we also have, I think we've had Kurzad Mehta. Is he?
Yeah, so it's four of us.
Well, all right. So I don't have much to cover on him, but then I noticed that he is a multilingual attorney, apart from his favorite language, immigration law. That's what I read about him. A quick background here. Murthy Law Firm has been in business for serving the community, immigration community, for the last 27 years, with over 100 members on staff, which includes attorneys, paralegals, and administrative staff, operating from headquartered in Maryland with a satellite office in Seattle, I think even in Chennai, India. And before I get to introduce you, Ms. Murthy, be sure to read Being Sheela, biography by Aditi Rao, that was recently published. A wonderful book. You can learn a lot about her journey as an immigration attorney. And they have, if you have a case that you'd like to discuss, this show is completely for informational purposes. There is no legal advice here. If you need assistance with your case, you should seek a consultation with Murthy Law Firm. I have just flashed the phone numbers and their web address. They are usually overbooked, so if you need a consultation, phone consultation, or they want you want them to handle your case, so make that booking. And you can ask a general question. If you're asking a question, please limit it to one question. And I have a little background about Kevin here. Kevin has been working with the firm since 2007, and he's the compliance guy from H1B and the I-9 compliance cases, including the mandamus filings. And he has been helping draft the curriculum proposals for employment-based immigration laws. And he has been working actively on MTR's notice of intent to revoke and denials for H1B, L1, F1 petitions, including the public access file LCA compliance with the Department of Labor and FDNS site visit investigations. He's been instrumental even with the I-140 uh, filings based on exceptional merit ability. And we also have Aaron here. He's also a managing attorney at the Murthy Law Firm. He established the firm's teleconference, which everyone's aware of. Earlier, I think it was Murthy Chat. They also had the teleconference. Now, I think this is a weekly or monthly teleconference that they're on. And I think he's instrumental in helping with the teleconferences. And he's been assisting with working with senior officials from during the closure of Tri Valley University, Department of working with Homeland Security and the Indian ambassadors as well. And I don't have Purzad. I do have, I'm sorry, Christopher, I don't have, I will definitely come to you. But then Miss Murthy, again, introduction is not required. She's the, once again, being Sheela is the recent biography published by Aditi Rao. Please pick up a book if you have not already done so.
And you can get it on beingsheela.com, actually.
Beingsheela.com. Thank you. And she's a prominent lawyer in the US by LexisNexis. There's a lot of awards here, but she's amongst the most influential lawyers in Maryland and the CEO in Maryland, 50 most influential Marylanders. And then Global Leadership Award for State of Maryland, Ernst & Young Entrepreneur of the Year. She has an LLM from the Harvard Law School. She's featured in the New York Times, Newsweek, ZTV, and Sakshi TV as well. And once again, if you'd like to schedule an appointment, you have a phone number right there on the screen, and you can also visit them at murthy.com. All right, so let's get started with you, Ms. Murthy. Since the past administration, before we jump into the Eagle Act, since the past administration, as you know, there has been a roller coaster ride on the immigration landscape, even before the pandemic, with the executive orders, travel bans, DACA, H4 EAD, H1B issues, and now the pandemic has, overturned the entire situation, specifically for, I think, Indian nationals, with the closures of consulates for almost a year and a half for both immigrants and non-immigrants. And President Biden wants to simplify the immigration, but many administrations, as I see, have failed or made it worse for obtaining GCs. What is your take on this?
Good morning, Dan. Good morning, everybody. Thank you so much for that wonderful and kind introduction. As I often say, the reason I look so good and get all these fabulous awards is because I have my incredible legal team at the Murthy Law Firm with attorneys like Aaron, Chris Drynan, Kevin Andrews, and our amazing team of attorneys and paralegals. Clearly, each administration has its own, to some extent, use the word bias or agenda when they start in office. As we know, President Biden was determined to remove some of the barriers that were placed by the prior administration with respect to legal immigration. There was a lot of concern with everything that was going on. And so on the very first day, I don't recollect any other precedent that I've been in the United States over 35 years, that on day one of his administration, on January 20th of 2021, his first day in office, he introduced, as we know, the USA Citizenship Act. And one of the many things was elimination of the per country quota limit. So we know that that's been going on. We know that it's a very important aspect of his agenda. We know he's tried to go back to the deference memo and several other topics with relating to the H1, the green card, the elimination of per country quota limits for particularly beneficial to nationals of India. And so there's a very big agenda, and we could talk a lot more amongst Aaron, Chris Drinan, and Kevin Andrews and myself on all of the different things that we have been noticing with respect to non-immigrant, immigrant, as I said, per country quota limit tentative law that's been introduced. And you mentioned the Eagle Act. So we really hope we'll have some time to go over a big, broad framework and then be able to answer a lot of the questions that I know people are anxious to try and answer. So I'm honored and delighted to be here and happy to showcase the wealth of knowledge and talent with Aaron, Chris, Kevin, and myself this morning. Thank you, Dan, for this
Thank you.
opportunity. And I
All right.
know this is a weekly
Thank
call.
you. Let's jump to Christopher. Chris, can you give us a quick introduction on your background and how you are associated with the law firm and how you can help the American dreamers?
Well, thank you, and again, it's good to talk to everyone this morning, and thank you for having us on. I've been practicing immigration law for almost 21 years at this point. I've been with the Murthy Law Firm for about 11, and I'm in what we call the Special Projects Department. We deal with sort of the more out of the norm and complicated cases that we deal with. And it's again, it's an honor to be here this morning. We deal with lots of people who are really seeking the American dream. A lot of people who are here on H-1B visas who have been here a long time. A lot of people who are waiting in the green card queue, which for people born in India is very, very extensive, as everyone knows. So it's on a day-to-day basis, we deal with people who are having various issues, either with their current non-immigrant visa status or with their ultimate goal to get a green card in the U.S. So it's we basically see a little bit of everything at Murthy Law Firm, and we pride ourselves on being able to help people with difficult cases and help people get their lives back on track when they, for various reasons, a lot of times through no fault of their own, something has gone wrong or someone has made a mistake or the government has made a mistake. And we do pride ourselves on being able to help people who are in tough situations.
All right. Thank you. Kevin, I'd like to ask you the same question. How long you've been associated with? I know I've seen you 4 or 5 years ago at the. I think people are still there, so I thought I'll see brand new faces. But then, so what is that you do at the law firm and how you can help the community? How you've been helping all these years?
Yeah, thanks, Dan. I really appreciate the opportunity. So yeah, I've been with the Murthy Law Firm for over a decade, and I started there as a paralegal. I went to law school while I was working with my mentors at the time were always Sheela and Adam, and we call Chris at the firm, we call him Chrisopedia, because all the little nuance questions he knows the answers to from his extensive experience. What I do mainly these days is work with our H-1B team to try and work through getting the H-1Bs processed. You can't get a green card dream going unless you're able to get to the U.S. and start working now. And as you know, between the previous administration stress testing all of the nuances and the ambiguities and gray area of immigration law and the economic situation caused by the pandemic, there's been a lot of disruption to people's day-to-day lives. So I think mainly what I do, I try to help people strategize when their career opportunities hit a wall that is their immigration strategy. A lot of times I talk to people and I say, hey, congratulations on that job offer, but I'm really sorry you can't take advantage of this without significantly delaying your green card case. So we mainly help brainstorm people on dealing with crisis, dealing with opportunity, making sure they're able to still pursue their career, put food on the table for their families, and all that, deal with all the crazy travel and and pandemic issues that are going on right now. So my day to day right now is mainly helping people work through all the immigration, economic, and career stuff that's being thrown at them, and if it's being thrown at them at the right time or not.
And Kevin is primarily in the H-1B non-immigrant department, so he does a lot of the H-1s, the L-1s, all kinds of different situations, complex, like we talked about, RFEs, notice of intentions to deny, regular cap subject H-1 petitions, just advising, consulting. So the main focus of Kevin is in the non-immigrant visa department. Chris is more the generic sort of similar to Aaron and myself. So actually, this show has three senior attorneys, and Kevin, who is by most standards senior, just for us, he's our baby attorney because, of course, he started here. I used to call Aaron my baby attorney. Now we have Kevin as our baby because compared to all of us with a little more gray hair, Kevin is our baby, but he has a good 10, 15 years at the Murthy law firm at this point. So we're totally delighted, more than 15 years at the Murthy law firm. Which is such an honor and a privilege to have about 15 years at the Murthy law firm. And he's the baby, the least experienced compared to us gray-haired people. But our goal is always to support, educate, empower, and enlighten people with respect to immigration laws, mentor them, guide them, help them. And the Murthy.com website is extremely rich in content and information, with tons of information. I remember 27 years ago when we first started Murthy.com, which is still the world's most popular legal website. A lot of lawyers would get upset with us because they were like, why are you guys giving away all this information for free when we all can charge $200, $300, $500, or $1,000 for this advice? But my goal was I went through a dark and difficult period with my immigration in the United States. I didn't have the hand holding and support from my lawyer. So I was determined that nobody else should suffer.
All right, thank you. Aaron, now, I know you have a lot of interest here in J1 and the physicians, visas for physicians now, and you're also a mentor for the other attorneys. So, how you mentor the other attorneys and how you help the community? Have you been helping all these years as a managing attorney at the Murthy Law Firm?
Sure. So first of all, J1 is more of a Korzad Mehta, who's not here. Korzad does the doctors and J1 visas. So I'm going to just put that to the side. I don't want to false represent. I've been, so first of all, thank you, Dan, and it's been an absolute honor and pleasure to be on your show. I'll tell you that I echo a lot of the sense. First of all, I'm delighted that Sheela started to call another attorney at the firm her baby attorney. And Kevin, I've been called that for the last 20 years. So it's a good term of endearment. I will tell you that I like winning and I like helping people as they move through their journey to accomplish their American dream. And to echo all the sentiments of Sheela, of Chris, and of Kevin, we see that for people from India, the journey is a very long journey. And so sometimes you have to look at immigration and not think about how much you know the law, but how much you care about how the person gets and accomplishes their goals. So almost in a way, a philosophy of saying, when does your life need to revolve around immigration? And when can immigration revolve around your life to a certain extent so that you can accomplish your goals and still continue your journey safely towards your American dream? To that end, I work with our new associates that come into the firm. We have training sessions, and I'm delighted to be a part of that. I do a lot of work with CBP, Customs and Border Protection, from that with people coming into the U.S. and the various trials and tribulations of people that get stuck at our port of entries, get turned around, get found inadmissible, those types of issues that come up, especially for students and for H-1B holders. I deal a lot with strategizing with companies to help them prepare their perm cases for preparation, organization, and filing. And I try to act as a general resource to support our teams to balance the work and make sure that everything can be done in a timely manner without skimping on the quality that Sheela Murthy is well known and well deserved and fought for.
All right, thank you. Now, I'd like to get started with the most anticipated topic. Um, and I'd like to start with Christopedia. Can you explain our viewers what is this Eagle Act of 2021, which was introduced by Zoe Lofgren and John Curtis? And how different is this from the S386, HR 1044, so on and so forth? Chris?
Oh, sorry, I apologize. Well, the main thing that this proposed legislation does is it removes the per country cap on employment-based cases, which is the main holdup currently for people who are born in India or China. Obviously, because of their large populations, they use up the overwhelming majority of immigrant visas. And that's what has resulted in the backlogs for people born in those countries over the years. And this legislation, if it's passed, would eliminate those employment-based per country caps. As far as the family-based quota goes, it raises the quota from 7% per country to 15% per country, which is a pretty sizable increase. Now, I believe the main difference from the bills we saw last year is that this bill phases these changes in over a 9-year period. One of the concerns that was raised about the bills last year is because the way the current system is structured, the majority, almost all of the older cases in the system are for people born in India and China. So if you were to eliminate the per country cap, all of a sudden, it would basically mean that people from the rest of the world would not get green cards for a very substantial period of time. So what this legislation does, which I think is a little different, is it phases it in over a 9-year period to sort of equalize the way the green cards are issued a little bit, so that we don't have a situation where only people from India and China are getting green cards and no one else from the rest of the world. So I think that is one of the changes in this bill.
All right, thank you. And back to you, Sheila. Right now, I think there is a backlog of about 481,000, about 482,000 immigrant visas held by the NVC. And as you know, there has been an 80% reduction in the non-immigrant visas from the 720,000 pre-pandemic, and then which dropped to about 125,000. Now, two things here. The USCIS, Department of Homeland Security, as you know, they're funded by the fees. Now, the reduction in processing cases has definitely led to a financial disaster for the agency. So, what is the correlation, if there is one? Do you anticipate anything to change? And there's still problems going on with H-1Bs and the H-4EAD delays for up to 15 months. And then the visa processing at the consulates is in a limbo. So, can you give more information to our viewers today about what you think and what do you perceive for the near future?
Wonderful. Yes, absolutely. Thank you, Dan. So there is this huge, huge backlog, as we know, both with non-immigrant visas and with immigrant visas, primarily because of the pandemic, because consular posts have been closed for the last almost a year, over a year at this point, from March of last year, March, April, so 14, 15 months. Plus, on top of that, we had the 2 presidential proclamations issued by the prior president, both for non-immigrant visas and immigrant visas, which dramatically impacted the ability of U.S. consular officers to issue H-1B visas, approved issuances in those countries. So those caused even more backlogs. And because of the non-usage of both, because primarily immigrant visas are issued by the U.S. Department of State at U.S. consular posts around the world, that's what caused so many immigrant visas not to be used in the past year. And all those unused primarily family-based cases slip over and they come into the employment-based category. So Charlie Oppenheim, the head of the Immigrant Visa Control Unit with the U.S. Department of State, spoke to us a couple weeks ago at the at the American Immigration Lawyers Association, Washington, D.C. chapter for Maryland, Virginia, and Washington, D.C., and explained that we would get, and we have written about this also on Murthy.com, which has tons and tons of free information, as all of you know, with respect to having all those numbers. So normally every year, we only get 140,000 immigrant visas for green cards for around the world, EB1, EB2, EB3, the employment-based categories, right? So instead of 140, we are getting almost double, 275,000, which is just a little under double only for employment-based from the unused immigrant visa numbers used in this past year. With respect to the H-1B visa issuances, again, people who thought they were going to meet their parents or family or for a wedding or to take care of a relative last year in March, or unfortunately got stuck if they were waiting for the visa to come back for months and months and months. Some of them have been stuck for 6 months or a year. Family members have been stuck. Now, if you had a visa stamp in your passport, obviously you could try to re-enter, except that now, of course, at the present time, President Biden has put a sort of a little bit of a halt because of the spread of COVID-19 in countries like India and several countries, including United Kingdom, Schengen countries, Brazil, China, etc. So you have a reduction in H-1s, you have a reduction in the immigrant visas. With respect to fee payment, paying all the bills, or basically funding USCIS, Dan, what we've seen is it's true that the number of H-1 petitions filing this year because of the economy has definitely reduced, both last year and this year. But we also see the economy starting to sizzle up with unemployment being almost at record lows. So there is definitely a need for high-skilled professional workers in the United States. The big part of the problem was the prior administration issuing RFEs and denials and notice of intentions to deny, which resulted in many employers losing interest in hiring H-1B workers because they felt, what's the point after spending thousands and thousands of dollars in legal fees and government USCIS filing fees, we're not even getting the approval. The US Department of State is not as directly funded by the Department of State immigrant visa fees like the way USCIS is supposed to be. But remember, they passed the law also with respect to premium processing. So even though there's a law and USCIS has not yet issued the forms, the premium processing fee has increased to $2,500 for H-1Bs, for H-4 EADs, for L-2 EADs, E-2 EADs, all the EADs, for including 485 EADs, which should become available as soon as USCIS issues the premium processing forms. So it benefits USCIS, and also there has to be a change in the whole mindset and culture. We have seen this mindset that unfortunately from the last 4 years, where people were trained and told how not to support and not to approve even legal immigrants, even though the talk was always against those breaking the law. The fact is, employers, universities, hospitals, tech companies have been badly impacted by the inability to bring people on H-1B or L-1 or O-1 or any other non-immigrant category. So you're right, it can be a win-win for USCIS if they start processing cases faster. Now also remember, Dan, last year in October, November, tens of thousands of cases were filed for 485s with the EADs and the APs last October and November of 2020. And so all those filing fees resulted in an unexpected huge amount of money that came into the US Department of Homeland Security / USCIS. So they keep complaining that they have less money and Congress needs to give them more money, but we cannot reward bad behavior. If they don't process cases quickly, if they don't move cases fast, if they don't take care of their clients or customers, you know, they have removed the phrase that America is a nation of immigrants and we are here to serve our customers, because the prior administration removed that from the mission and vision statement of the USCIS. If we don't have a mindset of how to take care of our clients, how can we take care of our clients? So I'm very glad that the Biden administration is trying to remove barriers to immigration, is trying to help employers, employees, and families, is trying to come back to the core purpose of serving clients, customers, which includes employers, employees, and their families. So I've given a quick overview. I know that we can, as we said, get into the nuances and the details. And I know there's a lot of people getting excited about asking questions as well.
Right.
So I want to make sure we
So,
give them some time.
thanks for that wonderful and a brilliant explanation. Now, before we continue, I have a few questions into Aaron, Kevin, and Christopher as well. But then people waiting, please flow in those chat messages, and I do have people waiting to ask a question. I will open lines for about 10 minutes. We'll answer a few questions and jump right back into the topic. So I have, people who are chatting, sending those messages. Thank you. I see a lot of these messages. We will definitely try to cover as much as we can. I'll try to open up phone number ending 3206. You're on the air. Hardik, please ask your question. Hello?
Can you hear me?
Yes.
Yeah. So currently, my H1B is expiring on 6th July 2021. So my current company is applying pension. In the meantime, I got an offer from other company and paperwork is currently going on. So I think it will be a simultaneously both one apply H1B transfer and H1B extension. So is it okay that if my current company applies for H1B extension and other company applies for H1B transfer, and if any of them approval comes first, like if the H1B transfer approval comes first, can I move to that other company? Or if the H1B extension comes, means I want to know is there an impact on sequence of approvals or RFP, any issues on that particular front?
All right. Did you get that, Ms. Murthy?
I think I did. It said basically that he's applying a couple different, his current employer is filing an H1 extension, a couple other employers, also another employer has filed it. Can he jump to the new employer? Should he wait for the current employer's extension? So it really depends, I guess, on the last action rule. And I invite others to jump in as well on my team. But there's something called the last action rule the USCIS uses. Whatever is the latest action of the USCIS determines your status. So if a person has multiple petitions or applications pending with the USCIS, then the USCIS generally looks at the last action, whatever was the last action of the agency will determine the person's status. So for example, if the H-1B extension with the current employer is approved first and then the new one with the new employer, then the latest one is considered the valid status or valid extension. If the person doesn't want it, they would have to request USCIS to revoke or withdraw the approval. So then it won't be binding on that person and won't impact that person's status. So again, we're getting into a lot of nuances here. And as long as you understand and if you get what you want and you want to work with the new employer, then make sure that that's the one that remains valid and the other cases are withdrawn, Hardik. I also see lots of questions here on the chat itself, Dan, about people whose perms were filed, etc. So I'm sure we can take turns if you want and go over these questions.
I'd like to have, jump into Chris. You see the question on your screen. My priority date is 27 October. I got another offer. Can I make this move? It's not very clear. Facebook user, I don't have the name, but then if you can answer this question for this Facebook user.
Well, I'm going to make some assumptions here. I'm going to guess that this is a person who's on H-1B status currently, so working for an H-1B for an H-1B employer, and they're asking whether at this point in time it's advisable to move to another H-1B employer, and that's really a judgment call. I mean, if we're talking about an October 2017 priority date, absent passage of some legislation or some major change, probably you've got some time before that date is going to be current. The issue is you don't want to be in a situation where you move to a new H-1B employer, therefore necessitate the filing of a new perm case, new I-140, and then suddenly have your priority dates become current without any ability to file your 485 application. So it's a judgment call. 2017 October might be a ways off. depending on the movement of the visa numbers and depending on any legislation. And if that's the case, then yeah, you could likely move to another H-1B employer and get a perm case and an I-140 through in time to utilize that priority date when it becomes current. But again, it's a judgment call, and really, when you make a decision like this, you have to consider your career. I mean, is this a much better position versus the stability of staying with your current employer, which potentially here has an approved I-140 that you could utilize if the dates happen to become current. So you really have to consider all of that in sort of a totality of the circumstances. How does this affect your career, and how does this affect your possibility of using that 2017 priority date?
Good point, Chris. And many times
Yeah.
when people ask me to guess the priority dates, I always say, if I could guess the priority dates, if I could guess the lottery number for the $500 million lottery or whatever, that would be a different world, right? At the end of the day, even Charlie Oppenheim, the person in charge for the entire country for the movement of immigrant visa numbers, has said that it depends on the USCIS usage of immigrant visas. It depends on consular post, issuance of visa numbers. Last year, we had two presidential proclamations by the prior administration blocking immigrant visas coming in. So there's so much that nobody can control. The pandemic in the United States seems to be in our rearview mirror, but in India, it's still going very strong. So they may say, as long as it's unsafe for people to come in from a country like India, they may prevent the immigrant visa blockage could exist. So there's so many unknowns, as Chris just pointed out. It seems unlikely, even with the Eagle Act that Dan just mentioned, it's only going to slowly phase in the immigrant visa numbers. And so it's not going to be a sudden dumping of hundreds of thousands of extra immigrant visas just for Indian nationals.
Yeah, so I would just like to just add a little bit. Just to remember, in the Eagle Act, they didn't increase the total number of employment-based visas. So you had 140 before and you have 140 afterwards. And it's good to remember that rest of the world never used up all of their visas. So a lot of those were transferring over. And even with transfers previously, you didn't see enormous jumps in the visa numbers, even when they increased the numbers to 270K. So keeping that in mind, and that they're currently working in 2010, 2011 area. So I think 2017, you could probably, nobody knows for sure, but you could probably say it's not going to jump there too quickly. The one law that was passed on the one regulation that's relevant to you, which is important, is the one that was passed January 17th of 2017, which gave you two tools to be able to move to a new employer. One is if your I-140 is approved and you move over to the new employer will have to start the green card over from scratch, but you'll get to retain or keep your original priority date. And because the current processing time is taking roughly about 14 to 15 months, it's likely that they could process a permanent I-140 and get you back to where you are right now with the new employer, as long as they start the green card process early. The second rule, which is really neat, is if you stayed with that employer more than 180 days, or the case stayed alive, in other words, wasn't canceled or revoked within 180 days, that I-140 is approved. The employer can't revoke it or prevent you from using it from continuous H-1B extensions beyond the 6-year limit. So until the priority date becomes current. So these two tools, which previously were a little more ephemeral, a little weaker, a little uncertain, these two tools are definitely in your toolbox, as well as the fact that the Eagle Act is phasing it in, as well as the fact that the visa numbers haven't increased. So I would use those reference points when making a decision.
Okay, thank you. Before I open the next caller, we have some kind messages here. Mohan, good morning, Dan and Murthy Law Firm, for your great work for the community. Thank you. And Srinivas Reddy, likewise, thank you. Thanks for the message. Please send those questions here. We will try to cover as much as we can. I'm going to take the next call here. Phone number ending 1083. You are on the air. Please ask your question. Please, just one question, please. Thank you.
Yeah. My name is Prashant. Actually, I'm working on H-1B visa in the US currently, and my wife and my kid, who is my kid is US citizen. They're in India, and my wife got H4 visa stamping, a fresh stamping in February of 2021. My question is, can they travel back to US considering the current travel ban?
I can take it unless somebody else wants to jump in. Let's have either Kevin or Chris or Aaron, if somebody otherwise. I'm happy to answer the question.
Kevin, would you like to take this question, please?
Sure. So just to make sure I'm understanding, there's a child and spouse both have H4 visas. They're in India now. They got the visas in February, but they have not been able to travel. Question is whether the proclamation applies to them. Yes.
I think the child is a U.S. citizen.
Then yeah, okay. That's an important distinguishing factor there. Yeah. So because you have a child of a U.S. That's U.S. citizen under the age of 21, unmarried, the proclamation does not apply. They already have their visa, so they don't have to deal with visa logistics. They're able to travel. I think just bringing a copy of their birth certificate to show the exemption should be good enough.
Birth certificate, obviously passport of the child showing it's a US citizen, and maybe a printout of the regulation. What we found is sometimes CBP at the airport asks questions, but they're pretty familiar with the proclamation. Sometimes the airlines prevent a person from boarding the flight. Sometimes CBP at the airport, at the port of entry, has prevented people. But as long as they have the copy of the law and the regulation and the proclamation, hopefully it's not an issue.
All right, let's take this question from the Facebook comments. My priority date is, okay, we have done this. Sorry about that. My perm was applied in November 2020, and his 6 years is going to expire in the month of July. So what do I do?
I saw that there's a gap in status. Aaron, did you want to jump in?
So he said his perm was applied in November of 2020. Does he have was the perm approved? Does he have an I-140 approval?
I think it was applied, and it's not approved yet.
So if it's not approved, then it fits under the original AC-21 rule, which says if a case is pending for more than 365 days, you remain eligible for continuous one-year extensions beyond your 6-year limit. So I would say if the case is not approved, and what was the date that they filed the perm case? Do we know?
November, and it's July.
And his 6 years limit is going to expire this July.
So what I would be looking to do is I'd be looking to see if he has time to recapture. Time that he spent outside of the United States would be a possibility of recapturing time. I'd look to see if that's the case. I'd look to see how big the gaps were that he spent outside of the United States, because there's something called intermittent H-1B, which eliminates a 6-year cap. So you're looking to see if you could potentially use that to extend the time. If he's not able to use those, you're talking about a bridge of time between July, August, September, October, November, about 5 months plus minus. So if he's not able to use any of the other options, the worst case scenario that I would think of is that he could request a visitor visa to help him bridge the gap of time. And while he's waiting for the visitor visa to be approved, which is generally taking more than 6 months right now, he'll either cross over the 365 days, or potentially he'll get the perm case approved and the I-140 approval. In either case, at that point in time, he'll have two choices. He'll have three choices. He could wait for the visitor visa to be approved and then apply to transfer back to H-1B. He could apply for H-1B at that point while the visitor visa is pending, and he can request something called non-protunct, or reinstatement back into status. Or alternatively, he could simply request an approval for consular processing, and we all have to pray to our particular deity that the consulates are more open and more available, and that the bans are over, and that he'll be able to go to the consulate and get a visa and come back in. That would be how I would recommend.
And if he has kept a few days aside from his end of his 6 years, let's say a week or two, even if the B2 is pending, he can file for a change back to H-1B, but he cannot work until the H-1 petition with the change of status is approved by the USCIS, because once the 365 days crosses, he's eligible for the 1-year H-1B extension, like Aaron pointed out. But if he's kept a few days, then they will allow it as an extension of the H-1, even though there's a B2 sort of a bridge status pending in the middle. So it's a little bit tricky. We have to get into the nuances. Hopefully the company and the company lawyer are explaining this carefully to you. And if they're not, you really need to do some research, understand, and you're certainly welcome to consult with the Murthy law firm should you need specific information on this, because you don't. And again, in the other option, of course, which is not a safe time to travel to a country like India, if the company has a branch office in Canada and you can get a work permit to work there, you go there for 5 months so you can continue to work legally in Canada and come back. Because when you're on B2, of course, you can't work legally and you can't pay your bill and your mortgage and your rent payments and support your family. So that's a big drawback for many people, of course.
All right. Thank you, Ms. Murthy. But one thing I wanted to remind every one of you, we spoke about this with Ms. Murthy on the other shows. Don't get that advice from friends on WhatsApp groups and Facebook. You check yes or no, you're in trouble. It is going to haunt you forever. It's not worth it. I see, if you go to a hospital, don't see another patient. You should see a doctor. So keep that in mind. Don't even think about, I see a lot of these, on people start arguing about I've seen one person got into trouble because he took an example of another person who said, hey, this worked for me. And, God knows what worked for him. And then, you should not take that risk. You should definitely seek advice from a professional, experienced attorneys like what we have on the session today. So be careful, guys. I stress on this every time. No WhatsApp groups. Don't take advice. They're not authorized to give you any legal advice. They are also in a limbo just like you. Now, before we take more questions, we still have to continue with the eagle, the flying act that is going to fly. We don't know if this is going to fly. But then, Aaron, back to you. What is this DHS, trying to plan to reach the 46-page plan, not the bill, restore the trust in the legal immigration system? When did we have this trust and when did we lose it, or are they trying to rebuild the trust?
So I've been practicing for about 23 years. I don't remember a lot of trust. Just don't remember a lot of trust. But I think what they're trying to do is, I think there's a big push right now, which is an ABT push, which is basically anything but Trump. So they're looking at this in a very big, holistic type of review, and they're saying Trump certainly tried to put the spoke in employment-based immigration. Trump certainly closed the border. Trump certainly was pushing against the H-4 EADs. Trump was certainly pushing against various L2s, those types of things. All of those things were there. And I think what they're trying to do is they're trying to create an environment in which a lot of those things that Trump was doing, they're turning around and creating it to be much more inclusive. I know you said not to focus on the bill, but you see some really neat things in the bill that I think is an example of that. Just for example, there's a rule in the bill, for example, that says that if a person has an I-140 and they're not able to file because their priority dates are not current, after 2 years would be the maximum time they'd have to wait, and then they could still file their 45. And what's interesting is, even though the priority dates wouldn't be current when they file their 45s, they're saying in this bill that the 45 would be good for the Child Status Protection Act. So example, children who are aging out, turning 21 years or older, they would be able to freeze their age in time and be able to still be a part of their parents' case, which I think is an enormous benefit. And I think that's what they're saying when they're saying we're bringing back the trust, is they're putting out these types of policies, these types of concepts to kind of help people feel more comfortable with the immigration process as it moves forward.
All right. Thank you.
One of the questions being asked by Varun Kupam on the call, in the chat rather, is my H1 is approved for 3 years, but I want to go back to India to take care of family situation. Or some people say I'm stuck in India for the past 6 months. Is there a time limit on how long I'm allowed to stay and work from abroad and still be paid by the US employer? As we've said over and over again, if you're a citizen of India, you have an Indian passport, you have work permission, authorization in India, you are allowed to stay and work in India, physically in India, because many of the world's immigration laws, including US immigration, don't look at working for the US employer as a violation of US immigration law if you are physically located in India. The only issue that we've talked about is tax implications, because government of India will say that you are working and getting paid while working in India. You have to pay Indian taxes, not US taxes, even if the US employer is doing Social Security, FICA, and federal and state tax withholding in the United States. As long as the company is allowing their employees to do that, and there is no high security requirement or issue as with some federal employers for the employee to be physically in the United States, an H-1B employer can allow the H-1B employee to work in the home country, and there's no violation of immigration law. So Varun, hopefully that will give you peace of mind, and you can take care of your family or whatever situation is going on for a year or two in India, and it has nothing to do with the H-1B approval.
All right. We have some questions coming in from WhatsApp groups as well. I think this looks like a question from an employer. When an LCA is opened by the hour, how does it work? Would it be a 2080 math or actual hours work, because we filed the I-129 petition as an hourly wage? If the US Department of Labor audits our company, what will happen in terms of the uh, yearly wage, because we specified only hourly and my employees don't work the 2080 hours. Christopher, would you like to take this?
Yeah, my understanding is that we have an LCA that was approved based on an hourly wage. That was my understanding of the question.
That's right.
In that case, the employee has to be paid for the hours worked, but that also has to be consistent with the hours that are listed on the I-129, i.e., on the H-1B petition itself. It's going to have a number of hours that are listed on the H-1B application. And for the person to be in status, they actually have to work that number of hours. Now, sometimes you can put a range of hours on the actual H-1B, in which case you would be required to pay the person that hourly wage for the number of hours that they actually worked, but still has to be consistent with the hours that are listed on the actual H-1B application itself.
So they can use like a range like 30 to 40 hours on the petition?
You can.
Yeah, this is something, okay, all right. So whatever is watching, Varma, I think your question is answered. Thank you. And we don't have much time left, but then I would
Just
like to go
quick
back.
clarification for Varma, Dan. The full-time work has to be minimum 35 hours, can be up to 40 hours, but it cannot be less if it's a full-time job and they didn't put the range of hours. If they put the range 20 to 30, 30 to 40, then as Chris said, no problem. But if they just said full-time employee and they checked off full-time, then it cannot, according to Department of Labor, be much less than 35 hours for most full-time, 7 hours a day, 5 days a week.
So,
Yeah, and just to piggyback onto what Sheila's saying real quickly is just that even the 35 hours, the Department of Labor can push back on you and say, what do you consider full-time for your other employees? Because if you look at the definition that they use, they say it could be 35 hours, but when we're looking at the definition of full-time, we're looking at the employer's definition of full-time. So we look at the employer in general. If the employer has everybody else working 40 hours, but this guy is a 35-hour week full-time employee, they can still push back on the 5 hours of underpayment.
Dan, if I could just add one last thing, just like the mechanics of all this, as Sheila and Aaron and Chris pointed out, you need to check a box whether it's full-time or part-time on the I-129 and on the LCA. So if you say the part-time box, then you can list these range of hours. On the I-129, you also have to list the annualized salary on the supplement. So if it's full-time, and then they give the $50 an hour or whatever, the way we train our team is to, assume that that's a 40-hour job. So take that hourly wage, multiply it times 2,080, because 40 hours times 52 is 2,080. If they're specifying a time that's less than 40 but more than full time, like the range between 35 and 40, then we would use that number to annualize it. So the $50 times 37 hours or whatever, because you have to list the annualized wage. I think it's like on it's the H supplement, or it's another attachment of the I-129. So you'll have to not just list the hourly wage. You have to list the amount of time that they're working and be pretty specific about it.
all right. So thank you. Now, Kevin, this question is back to you, tying back into the Eagle Act. Uh, kind of. Now, there was a recent video from U.S. Department of State, Charlie Oppenheim, proposing the 290K. Aaron said, what is truthful? We had that answer. So this 290K, people are desperately waiting for the October visa bulletin to come in. And how how realistic is the 290K? And last year you've seen, there were downgrades, upgrades, upgrades, downgrades. This whole game is going on since 2007, if I remember correctly. People moved from, they're just juggling from nowhere, and except for people who were probably lucky enough in 2006 and 7, uh, I don't know if they fail to understand this whole process. Either ways, it's taking 7, 8, 10 years. So, what do you think about these 290K visas?
So, like Sheila and others have pointed out, the prediction game is very, very difficult, very, very challenging. I wouldn't have predicted Bitcoin would be 50,000, 40,000 this time last year. If I talked to a client in the summer of 2007 and they say, what do you think the chances are of everything becoming current next month? I'd say no way, and I would have been completely wrong. So I often tell my clients I don't make predictions. I map out possibilities. I got out of the prediction game after the 2016 presidential election. I just map out the possibilities.
Okay.
Yeah, so I like to just map out possibilities, and if the chessboard and the game evolves in this direction, then you move these pieces. If it moves in that direction, the other way. I don't like making the predictions because ever since 2007 and basically every presidential election ever since then, I've always been wrong. So let's just map out.
All
So,
right. Thank you. Now let's take one caller here. They've been sitting for a long time. Um, Phone number ending 7053. You're on the air. Please ask a quick question, please.
Yeah, currently I'm in L1A visa, sorry, L1B visa, and my visa is getting expired on this September. So, in case if my visa extension doesn't go through, can I have myself converted to student visa and continue working?
So you are on an L1B visa, and if the L1 does not get extended, that's the question.
Yeah, I'm going to apply for it, but I'm not sure if that will go through. In case if that doesn't go through, as a backup plan, can I do a, can I join a college and do a day of security without getting it stamped, or do I have to, or can I just go for the change of status and continue working?
Okay, thank you.
So as long as the L1 was filed and the person is eligible for the L1 extension, and they still have either 5 years on L1B or 7 year time on L1A, if it's L1B, then the person can work based on filing a bona fide timely filing, and they have 240-day extension under the regulations. So she can work almost for 8 months while it is pending. Even if it gets denied, then at that time she has to stop working. But if she thinks that, so in these kind of cases, you do not want to pay extra money to get a denial faster by doing premium processing program. If you're nervous about eligibility for getting the L1 extension for whatever reason, if you want to switch to F1 or F1 CPT or other things, well, then you can't work legally unless you have proper authorization. And the USCIS looks at L1 the F1 CPT as a little bit of a gray area. So you have to be very careful about this. From each of these questions, what I'm seeing, Dan, is that, 4 or 5 of us can give a little bit of change or nuance. All of us, 4 lawyers on this conference call, video, TV call, TV interview, will have additions or nuances or differences, because immigration is such a complex area. It's got so many nuances. There's the law, there's the statute, there's the regulations, there's guidance, there's policy memo, and then there's practice. And on top of that, we see what we've been seeing, what the CBP or the government officials at the airport, et cetera, can do for you. And so, as Dan said in the beginning, we cannot call this case specific advice, because for case specific advice, the rules are very clear. We can give you general information, we can guide you, but you need to discuss this, as Dan and I pointed out earlier. Make sure you get the correct information, because if there's an exception to the exception, then your case may be different, and everything that we discussed today may not apply to you, because we may not have all of the nuances pertaining to your case.
All right. Wonderful. So I think we're getting close to the time is going up. But then we will continue these sessions every Thursday. It will be 11 a.m. Eastern time as opposed to 10 that we did today with one of the attorneys or the panel, the wonderful panel, the ladies and no, the lady and these gentlemen today. But then before we end this session, I'd like to make sure you follow us on Facebook, Twitter, YouTube, and LinkedIn. Subscribe, search for Hire IT People, and also you can text us H1B at this number, and we will be able to send you those updates, immigration updates. And thank you. It's been a wonderful session. But before we close the session, Ms. Murthy or anyone here, would you like to throw some golden words?
My golden words is go to murthy.com for anything and everything, because we have a weekly update on murthy.com where we put the latest updates, any changes from US Department of State, US Citizenship and Immigration Services, CBP, anything in the world that's going on. In fact, next week is the American Immigration Lawyers Association annual conference, Wednesday, Thursday, Friday, starting actually on Tuesday, Wednesday, Thursday, Friday, Saturday, 5 full days. Tons of information. We have the head of the Departments of Labor, Department of State, Department of Homeland Security, USCIS, CBP, attending, answering questions where we ask them and get the latest developments. So when we get the latest news, we will share it with you. Free information on murthy.com, Murthy Bulletin, Murthy Chat, Murthy Forum, everything available. And all of us are 24 lawyers we have, plus the 100 staff, both here, and 35, 40 staff in Chennai, plus our Seattle team. And Hyderabad and Mumbai, there's satellite offices, liaison offices. We really look forward to continuing to help you and take good care of you and your family and your friends with respect to all immigration matters. We thank Dan Nandan and IT and the Hire IT team for running this as a service to help the community, and all of us on behalf of Murthy Law Firm, Aaron Finkelstein, Chris Drynan, Kevin Andrews, and myself, Sheela Murthy. We thank you for the honor and privilege of continuing to educate, enlighten, and empower the immigrant community as you go through this very stressful immigration law process. Please use murthy.com for everything in terms of free information available on the internet, on the website, and all of this different chat, question, forum issues, etc. Thank you very much.
Before we end the session, I'd like to take one more minute with Chris. Chris, what changes you expect with the H-1B visa program? Merit-based, higher wages, or nothing?
It's very tough to say right now. When I get asked about potential legislative or regulatory changes, I always tell people that it's really impossible to predict the future. Congress right now in the Senate, it's a 50-50 split between Democrats and Republicans. Makes it a difficult environment to get legislation through. Now, there's a lot of support for, I think everyone agrees that there need to be changes in the U.S. immigration system, because a lot of it just doesn't make sense anymore. But as to how that's all going to shake out, it's really difficult to say, because you have a lot of different interests, a lot of different factions of both parties that are competing here. And it's going to be a compromise, whatever ultimately happens. Is there a lot of support to removing the per country cap for employment-based green cards? Yes, but a lot of people also have interest in making changes to the H-1B program to ensure greater compliance, to reduce fraud, and there are people in both parties who have concerns about fraud or misuse of the H-1B program. So it's likely that any bill that's going to go through is going to have some component of that. But what it's ultimately going to end up as, it's really difficult to say. It's going to be a compromise.
Yeah. All right. Thank you once again. Thank you, Christopher, Kevin, Aaron, and Sheela Murthy, the powerful team from Murthy Law Firm. And thank you, audience. Thanks for joining. Please do stay tuned for next week, Thursday, 11 a.m. Eastern Time. Have a good day. Signing off. Bye now.
Thank you.
Thank you.